Swayam Prabha. Digital India. Educated India.
Dr. Premchand, Associate Professor of Law from National Law University, Delhi. It is my pleasure to welcome you to this session on an intriguing topic in the law of property, that is mortgage. The concept of mortgage is very vast and has not been discussed in detail in any of the statute as per se. It is in existence since time immemorial and hence denotes a lots of things. It is employed at different times to express many varying ideas. Hence, the meaning of the term property can never be fixed. For instance, earlier where there were no intangible assets such as patents, copyrights, etc., property usually meant equitable goods. However, as we evolved, so did the kinds of property. Hence, the earlier meaning becomes incapable of including the new development and it. So, the Transfer of Property Act 1882 used the word property. However, it has nowhere explained the meaning of the same. Similarly, other legal instruments have also used the property, but have nowhere explained it. In the generic sense, property means an interest in anything. Property is a bundle of rights which includes title, possession and enjoyment, alienation. The property has been classified into many categories such as tangible and intangible, movable and immovable, corporeal, incorporeal, etc. Indian law, the Transfer of Property Act 1882 has adopted the movable and immovable classification. This act deals with the property of both the kinds of property. In the case of movable property, it is not necessary that the transactions should happen in written and registered form. However, the same becomes necessary in case of immovable property. Therefore, this shows by the classification of properties becomes important. This classification helps in determining whether procedure should be followed for the transfer of different kinds of properties. Hence, if the transfer has to take place, the most initial step would be to determine the kind of property one is willing to transfer. Once this is done, then prescribed procedure would be followed. The term immovable property as per se has not been defined in the Transfer of Property Act 1882. It just states what things cannot be termed as immovable property. As per section 3 of the Act 1882, standing timber, grass and growing crops cannot be termed as immovable property. If the meaning of a word, phrase is absent in an act, then the same can be looked into the other legal instruments. Hence, for understanding the meaning of immovable property, we shall refer to the General Clauses Act 1897 and the Registration Act of 1908 and try to consider it with the exceptions provided in the Transfer of Property Act 1882. Definition of immovable property, that is very important. Under section 3(26) of the General Clauses Act 1897 explains the meaning of immovable property as follows. Immovable property shall include the land, benefits arise out of the land and things attached to the earth, or permanently fastened to anything attached to the earth. This definition is also not an exhaustive definition, rather is only an inclusive definition. As the explanation starts with the word include, it shows that it only illustrates what physical objects or things can be included in the definition. Hence, it does not provide an exhaustive answer to the question raised before we started the discussion. Section 26 of the Indian Registration Act 1908 reads as follows: immovable property includes land, buildings, hereditary allowances, right to ways, lights, ferries, fisheries or any other benefit to arise out of the land, and things attached to the earth or permanently fastened to anything which is attached to the earth, but not standing timber, growing crops or grass. As the definition mentioned in the General Clauses Act is not exhaustive, similarly, the definition provided in this statute is also not exhaustive. Hence, the consolidation of all these acts would account for the definition of immovable property. The complete idea of immovable property after analyzing the aforementioned definitions is as follows: immovable property includes 1. Land, 2. benefits that arise out of the land, 3rd. things attached to the earth, and further we can classify the third point: 1. things embedded in the earth, things attached to what is so embedded in the earth, and third one is things rooted in the earth except 1. standing timber, growing crop and growing grass. So, the Transfer of Property Act 1882 deals with the transfer of immovable property and interest in the immovable property. Now, important point which we are going to start is the mortgage. There have been attempts, both judicial and academic, to describe a mortgage. Two of the most famous, at least to the difficulty of carrying out the task, is a satisfactory manner. Lord Macnaghten was moved to say in the case of Samuel versus Jarrah Timber in 1904 and Wood Paving Corporation 1904, that no one by the light of nature ever understood an English mortgage of real estate, while Maitland described it as one long suppressio veri and cessatio falsi. A mortgage is the transfer of an interest in a specific immovable property for the purpose of securing a loan. Mortgage in the ancient legal system was really a pledge where the property is being gauged, which was forfeited on default of payment. The whole transaction affected either by delivery of possession or by conditional convenience. This security is known as fiducia in Roman law. It means whatever the property value will be, it will be forfeited in case of non-payment. This was followed by pignus, which was a transfer not of ownership, but of possession without liberty to forfeiture. The latest one is known as hypotheca, a form of pledge without delivery of possession, under which the creditor acquires the power of sale. In India, the concept of mortgage underwent a similar process of evolving in Mohammedan law and Hindu law. Among Hindus, a mortgage by conditional sale was the first of its kind. In usufructuary mortgage, with neither power of sale nor foreclosure correspond to the Roman pignus. The simple mortgage is the latest form of mortgage following the concept of Roman hypotheca. In mortgage, there is a transfer opposition, but not the ownership. In Muslims, to avoid the Islamic prohibitions of interest, depressive mortgage by conditional sale, which was by bil wafa. It means sale with a promise so that the mortgagee enjoyed the rents and profits in lieu of interest and became the absolute owner of the property if the debt was not paid. In England, the concept of mortgage under common law was rather a pledge than a mortgage. The transfer was not of title, but of possession. In vivum vadium, the creditor took the profits of the discharge of both principal and interest. In mortem vadium or dead pledge, the creditor took the profits merely for the satisfaction of the interest. After the common law, mortgage became a conditional convenience and was modified by three principles of equity. Number 1, that equity looks to the essence of the transaction and that a mortgage is in a sense a borrowing transaction. Number 2, to that the borrower needs protection and that a condition that penalizes him is void. Number 3, that a condition of forfeiture in default of payment on the due date is a penalty. Although the essence of a mortgage transaction is the charging of property as security for the performance of an obligation, the transaction had for centuries been carried out by conveying an estate in land to the lender, thereby giving rise to the difficulty. These two facts were recognized by Lindley M.R. when he formulated his well known description of mortgage in the case of Santley versus Wild in 1899. This was a case where the mortgage had been taken not merely as security for the loan, but additionally as security for 1/3 share of future profits, thus serving to demonstrate that mortgages can be raised to secure the performance of obligations other than payments of debts. The purpose of security is to afford the obligee some additional means of enforcing the performance of the obligation by or all extracting the money equivalent from the obliger. Thus, a lender is often unwilling to rely solely on the borrower's personal credit and requires a greater certainty of repayment than mere possibility of enforcing the claim in an action of debt. Another way is that the borrower can ask for personal security from a third party known as surety or guarantor. In that case, the surety or the guarantor undertakes to answer for the borrower's default by way of personal commitment. In case of borrower's default, and action can be taken by the lender against the surety. The surety may also reinforce his undertaking by giving a real security. Now, we look into the definition of mortgage. Prior to Transfer of Property Act 1882, there was no definition and no written law was in existence on mortgage. The Act of 1882 has not made any special change on the law of mortgage except providing some terms, rights and liabilities of the mortgagor and mortgagee or assignee. This enactment made the process of mortgage more systematic with detailed rules. It also determines the rights and liabilities of both the mortgagor and mortgagee. Chapter 4 of the Act of 1882 provides a set of sections from 58 to 104, which deals with the mortgage. Section 58A of Transfer of Property Act 1882 defined the mortgage. In the case of Gopal versus Purushottam 1883, Justice Mahmood says on the definition of mortgage in section 58, mortgage as understood in this country cannot be defined better than by the definition adopted by the legislature in section 58 of the Transfer of Property Act. The definition has not in any way altered the law, but on the contrary, has only formulated in clear language the notions of mortgage as understood by the writers of textbook on Indian mortgages. Every word of the definition is borne out by the decisions of Indian courts of justice. Section 58 runs as mortgage, mortgager, mortgagee, mortgage money and mortgage deed defined. Section 58A, a mortgage is the transfer of an interest in a specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan, an existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. The transferor is called a mortgager, the transferee is called a mortgagee, the principal, money and interest of which payment is secured for the time being are called the mortgage money, and the instrument, if any, by which the transfer is effected is called a mortgage deed. The first kind of mortgage is simple mortgage, which has been defined by section 58 as where without delivering possession of mortgage property, the mortgager binds himself personally to pay the mortgage money and agrees expressly or impliedly that in the event of his failing to pay according to his contract, the mortgagee shall have a right to cause the mortgage property to be sold and proceeds of sale to be applied. So far as may be necessary in payment of the mortgage money, the transaction is called a simple mortgage and the mortgagee a simple mortgagee. Another kind of mortgage by conditional sale, where the mortgager ostensibly sells the mortgage property on condition that on default of payment of the mortgage money on a certain date, the sale shall become absolute, or on condition that on such payment being made the sale shall become void, or on condition that on such payment being made the buyer shall transfer the property to the seller. The transaction is called mortgage by conditional sale and the mortgagee a mortgagee by conditional sale, provided that no such transaction shall be deemed to be a mortgage unless the condition is embodied in the document which effects or purports to effect the sale. Another kind of mortgage is usufructuary mortgage, where the mortgager delivers possession or expressly or by implication binds himself to deliver possession of the mortgage property to the mortgagee and authorizes him to retain such possession until payment of the mortgage money and to receive the rents and profits accruing from the property or any part of such rents and profits and to appropriate the same in lieu of interest or in payment of mortgage money, or partly in lieu of interest or partly in lieu of payment of the mortgage money. The transaction is called an usufructuary mortgage and the mortgagee an usufructuary mortgagee. Another kind of mortgage is English mortgage, where the mortgager binds himself to repay the mortgage money on a certain date and transfers the mortgage property absolutely to the mortgagee, but subject to a proviso that he will retransfer it to the mortgager upon payment of the mortgage money as agreed. The transaction is called English mortgage. Another kind of mortgage is mortgage by deposit of title deeds, where a person in any of the following towns, namely the towns of Calcutta, Madras, Bombay and in any other town which the state government concerned may by notification in the official gazette specify in this behalf delivers to a creditor or his agent documents of title to immovable property. with intent to create a security their own. The transaction is called a mortgage by deposit of title deeds. Last kind of mortgage is anomalous mortgage, a mortgage which is not a simple mortgage, a mortgage by conditional sale, an usufructuary mortgage, an English mortgage or a mortgage by deposit of title deeds. Within the meaning of this section is called anomalous mortgage. Now, we will look into the essential ingredients of a mortgage. A mortgage is the transfer of an interest in a specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan, an existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. The essential elements of transaction of mortgage are: number 1, parties to the mortgage; number 2, transfer of an interest; number 3, in a specific immovable property; number 4, the purpose is to secure the payment of money advanced or be advanced by way of loan, an existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. In India, at various regions, mortgage is known with different names. Like for example, simple mortgage is known as Bandhki Khat in Bengal region, Rehan R in United Province, Taran Gehan, Nazar Gehan in the province of Bombay, Drishta Bandhka Adaimana Patram Tanaka Panyam in case of Madras province. Another kind of mortgage, mortgage by conditional sale in West Bengal known as Khatka Bala or by Bil Wafa. Like in Bombay, this is known as Gehan Lehen. In Madras province, this is known as Muddata Kariyam, or the another form of mortgage which is known as usufructuary mortgage, which called in Bengal is Khali Khalasi or Bandhka Nama. In Madras region, this is known as Duggu Bhoyam or Swadhin Adha Maman or Kanom or Oti. Now, we will look into the ingredients of a mortgage. 1. Parties to the mortgage. One is mortgager. Mortgager is a person who transfers an interest in favor of another person is known as a mortgager. Mortgager shall always be a competent person to enter into a contract. He shall also capable to transfer the property. A minor is not capable to mortgage his property validly. A guardian of the minor with the permission of the court can validly transfer the interest in the property in favor of mortgagee. But such transfer without the permission of the court is voidable if the mortgage has been executed by many persons and some of whom are not capable of doing so. It remains valid and operative for those who competent to execute it. The mortgage by a judgment debtor or property under the management of the collector is void. This void mortgage will not affect the personal liability of the mortgager. Without the consent of the copartner, if Karta of a joint Hindu family mortgages the property, it will be voidable at the option of the copartner. A partner in a commercial firm, a Pardanasi lady can execute a valid mortgage deed. Second point of its essential is mortgagee. Mortgagee is a person who is competent to hold property, can be a mortgagee irrespective of his competency to contract. In a case, Allahabad High Court has observed that it is not the competency to contract, but competency to hold. The property is material. So, even a minor can be a mortgagee, but the latest position clarified by the Supreme Court that conditions of a valid mortgage are that both the parties and the mortgager and mortgagee must be competent to enter into contract. A minor being incompetent to contract cannot be a mortgagee. Number third is transfer of an interest in an immovable property. It is necessary to transfer an interest in the property for a specific purpose in any mortgage. For example, in simple mortgage, transfer a right to cause the property to be sold. In usufructuary mortgage, the right to purchase and enjoy the property is transferred. So, the same in an English mortgage, what is transferred is the ownership, while the mortgagor has a right to redemption or right to get back the property from the mortgagee. Point number 4, the purpose of mortgage. Every mortgage presupposes the existence of a debt, actual or contingent, and it is for the purpose of securing the repayment of the debt that a mortgage of the property is made. Right in property is an accessory to the right to recover the debt. Hence, transfer of property made to discharge the debt. One property can be mortgaged many times, but additional debt and introducing a co-mortgagee not alter the relationship of the first mortgagee with the mortgagor. The term performance refers to an act mortgagor resulting from an engagement. This engagement may incur financial liabilities. We can take some examples where a borrower cedes from B and mortgages his filled to secure its return, an agreement to withdraw, an appeal, and an agreement to secure payment for the subscriber of a chit fund. Mortgage depends on the nature of the substance of the document. The intention of the parties is to be determined by the jural relationship created by the document. The substance and intention of the parties cannot be inferred from the deed to create a relationship as in the mortgage, even if the word mortgage is being used in the deed. To ascertain the intention of the parties, surrounding circumstances including oral evidence can be taken into consideration. Now, we can sum up. Section 69 of the Transfer of Property Act 1882 represents a distinct exception to the conventional legal framework, granting a mortgagee or their authorized representative the exceptional right to sell mortgage property without court intervention. This provision underscores the autonomy afforded to the mortgagee, enabling them to act independently of the mortgagor's wishes, thereby facilitating a more expedient resolution to mortgage defaults. It is crucial to note that the legislation does not inherently grant English mortgages possession rights upon mortgage execution, suggesting a deliberate legislative stance to avoid introducing inconsistencies within the law. The practice of allowing the mortgagor to retain possession akin to English legal principle signifies a nuanced approach to balancing the rights and interests of both parties involved. Despite the historical relevance of English mortgages, their practical utility has diminished, reflecting evolving legal interpretations and fundamental rights enshrined within the section 69. The recommendations for legislative clarifications regarding possession rights under English mortgages further indicates a need for reform, ensuring that mortgage laws remain equitable and aligned with contemporary legal standards. Ultimately, the power of sale provisions serve as a critical mechanism within mortgage law, advocating for efficiency and fairness in the resolution of mortgage disputes. So, goodbye, thank you, we will meet in another lecture.